One post, one tweet, one Instagram story. That's all it takes to end a sporting career worth crores. Imagine training for years to represent your country, winning medals, securing sponsorship, and then losing everything because of a few words posted online. Sounds unbelievable. Well, it has already happened. So, today we are discussing a few fascinating questions like, can athletes actually be banned for their social media post? The short answer is yes. But the legal answer is far more interesting. Social media has transformed athletes into global influencers. Now, years ago, athletes communicated through press conferences and interviews. Today, they communicate directly with millions of followers through Instagram, X, Facebook, YouTube, and TikTok. While this gives athletes unprecedented freedom, it also exposes them to legal and disciplinary consequences. The first thing to understand is that athletes are not just private individuals. They are often bound by contracts, code of conduct, sponsorship agreement, federation regulations, Olympic charters, and league rules. When they post online, they are not viewed merely as citizens who are expressing their opinions. They are viewed as representatives of their teams, leagues, countries, and sponsors. One of the most famous example is Israeli rugby player and Australian athlete cases involving controversial posts that were considered discriminatory or offensive. Sporting organizations across the world increasingly monitor social media activity because online content directly impacts their reputation. Now, several sports federations now have detailed social media policies that prohibit hate speech, discrimination, discriminatory posts, remarks, harassment, threat, or conduct bringing the sport in disrepute. A landmark example is the case of Australian rugby star Israel Folau. So Folau posted religiously motivated comments on social media stating that certain groups would face divine punishment. Rugby Australia concluded that the post breached its professional code of conduct and terminated his contract. The dispute became one of the biggest sports law controversies in the world and eventually resulted in a settlement. The case demonstrated that even an athlete claims freedom of speech, but sporting organizations may argue that contractual obligations and code of conduct justify disciplinary action. Another fascinating example involves Olympic swimmer Ryan Lochte. So in 2018, he posted an Instagram photograph showing himself receiving an intravenous infusion. Anti doping authorities investigated the image and ultimately suspended him for 14 months because the infusion violated anti doping rules. Ironically, it was not a failed drug test that exposed the violation, it was his own social media post. Now, this raises a very important legal question. Do athletes have freedom of speech? Yes, they do. However, freedom of speech is not absolute. In most jurisdictions, including India, reasonable restrictions can apply. More importantly, professional athletes voluntarily agree to contractual restriction. When an athlete signs a league, federation, club, or sponsor, they often agree not to engage in conduct that damages the reputation of the organization. Countries worldwide generally recognize the distinction between state censorship and contractual discipline. So, if a government punishes an athlete for expressing an opinion, constitutional questions may arise. However, if a sporting federation disciplines an athlete for violating uh, agreed conduct rules, the issue is usually treated as a contractual matter rather than a constitutional one. Sports governing bodies have particularly become very strict regarding hate speech, racism, sexism, homophobia, religious intolerance, harassment, and abusive online conduct. FIFA, for example, has directly expanded its efforts to monitor and combat abusive online content directed at players and teams. FIFA's latest initiative includes AI-driven monitoring system which is designed to identify and suppress abusive messages, and offenders may face bans from FIFA related events. Athletes may also face sanctions when social media activity undermines the integrity of the sport. Now, anti doping agencies increasingly monitor online activity because athletes often reveal information that may trigger investigation. Researchers have noted that social media is becoming an important tool in doping prevention, enforcement, and athlete monitoring. The Olympic movement provides another example. Now, Olympic athletes are subject to strict rules governing commercial endorsement and sponsor related social media activity during the Olympic period. Now, athletes who violate these regulations may face disciplinary consequence because the Olympic ecosystem relies heavily on broadcasting and sponsorship revenue. Now, let's look at the legal principles which are involved. The first principle is bringing the sport in disrepute. Most sport federations have broad disciplinary provisions allowing sanctions when an athlete's conduct damages the reputation of the sport. The second principle is a contractual compliance. Athletes often are employees, contractors, or federation members. Their contracts usually contain morality clauses and social media obligation. The third principle is proportionality. Even if violation occurs, disciplinary action must be taken and that should be proportionate. A minor mistake should not automatically result in a lifetime ban. Arbitration tribunals and courts frequently examine whether the punishment matches the severity of the misconduct. The fourth principle is, of course, principle of natural justice. Before imposing a ban, organizations generally must provide a notice, an opportunity to respond, and a fair hearing. Failure to follow due process can result in disciplinary decisions being overdue. Now, let's bring this decision closer to home. In India, Indian athletes are usually governed by federation rules, team agreements, sponsorship contracts, and codes issued by the sports authority. So, if an athlete posts content that is defamatory, discriminatory, abusive, or damaging to the reputation of the sport, disciplinary proceedings may follow. Now, depending on the governing regulations, sanctions can range from warnings and fines to suspension and disqualification. At the same time, sporting authorities may balance discipline with athletes' rights. Athletes, they remain citizen with personal belief and opinion. Now, the challenge lies in determining where the personal expression ends and the professional misconduct begins. The answer is rarely straightforward because the context matters. Now, was the statement hateful? Did it violate any contractual rules? Did it damage the integrity of the competition? Was the due process followed? These questions often determine whether a ban will survive the legal scrutiny. As social media continues to dominate the public discourse, athletes are no longer judged only for their performance on a field. They are judged by every post, comment, repost, story they publish online. A single post can create sponsorship opportunity, build global brand, inspire millions, or trigger investigation, suspensions, and career-threatening consequence. So, can athletes be banned for a social media post? Absolutely yes. But the real question is whether the post violated a valid rule, contractual obligation, or a code of conduct, and whether the punishment imposed was fair, proportionate, and legally justified. Next time you see an athlete post something controversial online, remember it may not be just a social media post, it may be evidence in a future disciplinary proceeding. If you found this analysis interesting, let me know in the comments. Should athletes enjoy complete freedom of speech, or should sporting bodies have a power to regulate what athletes post online? Follow for more interesting insights on sports law, media law, and intellectual property rights. Thank you.